Can a state prohibit transgender students from participating on teams that align with their gender identity? Does Title IX, a law that was passed in 1972 and says nothing about transgender individuals, protect those individuals in 2025? Jamie, are you ready to talk about our next Supreme Court saga?
Oh, I am ready, Chris. I am ready, but we have to talk about something else first. What is that
what's up?
thing? What is the thing on your face, Chris? What is going on?
What thing?
Like, why would you do that?
So for those just listening, I shaved mutton chops in my beard for Halloween. It's a Halloween thing. So the faculty here.
It better be. Because you look like you're straight out of the 1880s with a pair of headphones.
Yeah. And a microphone. No, we're doing a themed like hallway Halloween costume where we're all dressing up as characters from Clue.
Okay,
so I pulled Colonel Mustard, which I think I am rocking.
Yes. No, it's like that is legit, man. Like that is that is an 1880s kind of that. Well done. Well done. That is commitment.
Thank you.
That is commitment.
You got to commit to the bit.
Yeah. And just another disclosure, Chris and I are both sick right now. Hopefully we'll get through this episode without, our voices cracking and all of that stuff. But it's the fall and we both have small children and, it's just, this is what you get, I guess.
This is what you get.
Yeah. Okay. So, yes, like Chris said, this is a Supreme Court saga, or it will be most likely. We are going to talk about another consequential education-related Supreme Court case today. And it's probably safe to say that we've had a number of potentially consequential Supreme Court cases lately.
This court, 2 last term.
Yeah, 2 last term.
Well, 1 and then
then 2 other.
Swing and a miss.
Yeah, and a couple of less consequential ones like the E-rate thing. And anyway.
Oh, right. Oh, and the special ed one.
And
so
the special ed case. Yeah.
Oh, my gosh.
So we've got actually 2 cases that have to do with transgender athletes that the Supreme Court decided to take up in this upcoming term. And we're going to talk about one of those cases today. We don't know if they're going to combine them or what. Sometimes they combine the oral arguments.
Right.
Sometimes they'll combine the opinions.
They raise really similar questions.
Yeah, very similar questions. So we don't know what the court's going to do with it, but they're going to do something. The court hasn't been very shy about taking up a lot of these big issues lately over the last decade. Kennedy, Mahanoy, Mahmoud, the Oklahoma religious charter school case. They haven't been shy. And so now we finally, for better or worse, come to the first Supreme Court case about transgender athletes. We're going to talk about the case of Becky Pepper Jackson, otherwise known as BPJ in the court documents, but her name has come out because this is such a high-profile case. So this is Becky Pepper Jackson versus West Virginia. Becky Pepper Jackson is a transgender girl who was barred by state law from participating on a girls' sports team. This went back and forth in the lower courts, with Becky ultimately winning at the Fourth Circuit Court of Appeals. West Virginia wasn't happy with that, so they petitioned the Supreme Court, who agreed to take up the case, along with that other case, like we just mentioned. That was Little versus Hecox.
Right.
So here we are at the time of this recording, which is, where are we? We're right before Halloween, obviously, according to Chris's face.
Right, which is fun because everyone's going to see this after Halloween.
I know.
Which I also think we're going to record when I'm in costume because we're going to record on Halloween.
Oh, that's fun.
So people are going to see that in Christmas and be like, what is Chris doing?
Yeah, so as of right now, the oral argument date has not been set, but we're going to give you all of the background today so that you are ready to ride this roller coaster with us during the Supreme Court session of 2025-2026. Yeah.
Sounds fun.
Welcome to Chalk and Gavel, where we explore how the law shapes education, one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
The kids are alright. The kids are alright. The kids are alright.
Welcome back, everyone. A few reminders. Don't forget to rate and review Chalk and Gavel. You can find us wherever you get your podcasts. You can also find us on YouTube where you can see our beautiful faces.
Oh,
Please give the videos a thumbs up. That helps us get picked up by the algorithms and all that fun stuff. Leaving reviews is a huge help in that regard as well. We also have a big announcement. We've got a new website.
Oh, yeah.
It is beautiful because Jamie made it, and it is.
This is a very
so
DIY. It's a very DIY show.
It's the website though is now very professional, and it's not as DIY as it was before. So go check out the new website because
totally.
I am very proud of it, and I had nothing to do with making it. On our website, you can sign up for our new newsletter. You can also find more information about the show, our feedback form, other ways to get in contact with us. You can also find our teaching guide if you want to assign Chalk and Gavel for your classes or professional developments. And finally, our new website allows you to support us directly through the website. So we appreciate all of your support. $2 a month or whatever you want to offer to the show. That makes this show possible. And we really, really appreciate all of you listening and supporting the show over the last more than 2 years.
Yeah, that's crazy. 2 years we've been doing this. That's nuts. Oh, and the other real fun news that we can share now is that Chalk and Gavel, has been selected to do a live recording at South by Southwest.
EDU.
So the South by Southwest EDU conference, which is a couple of days before the big one in Austin, Texas, we were selected to do one of our episodes live there. So we are totally pumped about that. And
it's going to be fun.
Yeah. So that will come out at some point in the spring, I guess, because the recording is going to be in March. So that's cool. That's good news. Okay. It's probably going to be a long episode. Should we just go ahead and start?
Yeah.
It's enough of this talking. All right. So I got a bell ringer for you today. You ready?
I was born ready.
Excellent.
Though this morning I did not wake up ready.
No. Were you born with that thing on your face, though?
No, but it's growing on me.
Yeah, it is growing on you, literally. Jeez. Let's do this. Okay. So, this is a recent case. It's actually tied to one of our recent episodes, which was not a recent case. It was Bethel versus Frazier that we did a couple episodes ago. All this stuff is so interconnected, Chris, right? Like, I just find that cool. So back in mid-October, which is when we're recording this, but it's not when you're listening to this, the Sixth Circuit Court of Appeals, so that's up, includes Michigan, handed down a decision in BA versus Tri-County Area Schools. So this was a case that was out of Michigan about a district that banned students from wearing shirts that said, "Let's go Brandon." All right.
Oh.
Yeah. We're bringing this one back.
I was going to say, is it 2020?
It was 2021, I think, or 20.
Yep.
I think
that
2021.
makes more sense,
yeah. So the district won because they banned the kids from wearing the shirts that said, "Let's go Brandon." The district won, but it was a close one. It was a 3-judge panel on the Court of Appeals, and they ruled 2-1 in favor of the district.
Okay.
Now, so just to take things back a notch, like we said, this was around 2021. So this was during the Biden presidency, as the background here was Brandon Brown was being interviewed following a NASCAR win. Okay. The crowd started chanting "F Joe Biden." All right. I don't think they were saying F. And one of the reporters at the time said something like, "It sounds like they're saying, 'Let's go Brandon.'" Now, we have no idea if that reporter knew what they were saying and trying to sort of cover it up.
The syllables line up.
Yeah. or if that reporter didn't really hear what they were saying and thought that that's what they were saying. But anyway, it turned
became
into
a thing, right?
Right? Yeah. It turned into a thing.
Like
And
a coded anti-Biden message
yeah.
where you could basically say this without saying the F word.
Right. Exactly.
Yeah.
And so, I mean, this was a big thing, so we're probably not sharing anything new with all of you listeners about this. But so what happened was a couple of middle school kids, they were brothers, they wore shirts that said, "Let's go Brandon." And a school administrator said that it was the same thing as using the F word and told the kids to remove the shirts. I know where you stand on all this, Chris.
Right. Yeah. Like I think I agree with the dissent in this one.
I thought you probably would. So they removed the shirts, but then one of them wore it again a few weeks later. The district considered the whole "Let's Go Brandon" thing to be profane language, and they had specific wording in their dress code that prohibited profane language.
Sure.
All the stuff that the Bethel case
I was
gave
going to
us.
say, it's straight out of Bethel, lewd, vulgar,
Yep.
right?
Yep. It came
But like,
straight out of
"Let's
Yep.
Go Brandon" isn't. Right? Like, I get it's coded language, but like on its face, it's also political, right? Like, it's a statement about, at that time, the current president. So like, that is pure political speech. Yeah, sure, it's ambiguously vulgar because it references that, but like,
it's
to
not
me,
the actual
the value of the
language.
speech outweighs that.
Well,
'Cause if
to two of the judges, it did not.
Yeah, well,
they sided with the school, and they cited Bethel, and they basically said that schools have the right to prohibit vulgar and offensive language, and they also didn't care that it was political speech. They basically said that schools can regulate profanity, even.
and I don't disagree with that. It's the like, is this profane, right? Like,
Yeah, I mean, I think the parent said something like, it's the same thing as replacing hell with heck, right?
But it's not, though, because like those are like one for one. I don't know. Maybe they were just Brandon Brown fans. We don't know.
I have no idea. So, I mean, just to put a few speculations to rest, I do want to say that one of the two judges that sided with the school was a Trump-appointed judge. The other judge, I think, was appointed by Clinton. I think it was back in the 90s or something.
None of them were appointed by Biden, though, right?
No, no. And the dissenting judge was a Trump appointee, a later Trump appointee, I think. And he relied on Tinker instead of Bethel,
right?
Basically saying that because it's political speech, that should trump, for lack of a better word, vulgarity.
And I think that's where I would land. But that's like, interesting. That's a really interesting case.
It is an interesting case because it really blurs the lines between what is political and what is vulgar, and and what happens if you've got something that could be both. I mean, in your view, Chris, I see what you're saying. Like, it's really not both. It's much more political than it is vulgar, if it is vulgar at all.
Right.
But two of the judges thought that it was vulgar enough to invoke Bethel over Tinker.
Yeah.
Anyway, that was an interesting case.
Yeah. Highlights the line drawing issues.
Exactly.
Mm-hmm.
All right. Let's get into the Becky Pepper Jackson case. So the first thing I want to say is listen, folks, we have dealt with some charged topics on this show, but few have been quite as polarizing as what we're going to talk about today. And as with everything, Chris and I will do our best to try to be as objective as we can. But like many folks, we also have very strong opinions about this. With that said, there are many thoughtful, or at the very least, well-intentioned arguments on both sides. And courts have had very little deep and meaningful wrestling with these particular arguments. The kind of scrutiny that often comes through years and years, or even decades or more, of an issue that percolates through the courts. And so the facts and the arguments and the legal issues and the posturing, none of that has taken place with this issue of transgender students. None of that has taken place to the same degree as free speech and other forms of discrimination and lots of other issues. So, this is pretty fresh, right? So,
right. We're writing on blank paper.
Yeah, exactly. And because this is all about values and personal convictions and dignity and identity and fairness, we know that people have really strong feelings about this topic, because this is heavy stuff. All right. We're going to do our best to present the case as objectively and as fully as we possibly can, exploring all the different arguments and angles. But if there is one really important thing that I want to throw out there before we even get started, all right, a big takeaway: please be kind to one another. Okay. We can disagree, but we're all human, and we really need to treat each other with respect and care. And that is the most important thing. I tell my students that in my classes, when we talk about these topics, that it is true that teachers and administrators, they all have opinions and beliefs about these kinds of things as well. But at the end of the day, their responsibility is to protect every single kid in that school, even the kids that they disagree with in terms of this or that, right? And so that's one big thing that I want to say at the top of this episode is like, let's all be friends.
Anyway. Here.
Okay. All right. So let's talk about the Becky Pepper Jackson case. This is out of West Virginia. So West Virginia had attempts to prevent transgender students from participating on teams that align with their gender identity. And the decision that we're covering in this episode is the Fourth Circuit's decision, but that decision has been appealed to the Supreme Court, who agreed to hear the case in July. We don't know the oral argument date yet, like we said, but just like we did with Mahmoud and the Oklahoma case, we are going to follow this one all the way through, because this one, it's big. Okay?
Yeah. It's going to be I can't wait for the oral argument. It's going to be a fun one.
Yeah. Well, it might not.
I want Justice Alito to do some more literary criticism.
Oh, Alito. Okay, so this is about a law that was enacted in 2021. West Virginia passed the Save Women's Sports Act. And this law provides that, quote, athletic teams or sports designated for females, women, or girls shall not be open to students of the male sex, unquote. And that law defined male as, quote, an individual whose biological sex determined at birth is male.
Wait a second. Aren't you not supposed to use the word in the definition?
Coming from the former
Isn't
English
that
teacher.
the rule?
Yeah. Isn't that the rule? A male is a male.
Right. Yeah. But like that shows the issue. Like that is one of the fundamental issues in these cases is like defining words. Right. And how do you define sex? Like if the Equal Protection Clause and Title IX prohibit discrimination based on sex, what does that mean? We need to know what
that means. Yeah.
What is male? What is female? Like how we define those words. And one of the challenges here is like in society, like we talk about this stuff without a lot of precision. So like when we talk about male, we're not just talking about like biological sex or anatomy. We're talking about gender identity and how you like present yourself to the world. So like all of those things are wrapped up in these words. And here we're like, the big issue here is we're trying to understand and parse those words and apply them to legal doctrine. And like, I think, I make fun of them for using the word in the definition, but like that's the challenge of these cases.
And we can also go back and say that the law talks about sports designated for females, women, or girls. Like how are you defining the difference between those three terms?
Right.
Are girls?
Is there a difference between those three terms? Right.
Yes. Yeah. So,
right.
All right.
And that's one of the things, like when you have to add an adjective in front of something, like that means that word doesn't mean just that thing. Right. So by saying biological sex, you're like constraining the meaning of sex, which means that the meaning of sex is actually broader than that.
Exactly.
So there's so many, like, I'm a former English teacher. I'm going to nerd out a little bit.
All right. You do you, Colonel Mustard. Okay. So West Virginia had long provided for sex differentiated sports teams. Okay. So the sole effect of the law was basically just to prevent transgender girls from playing on girls' teams. There's been a rule on the books for at least 30 years in West Virginia that schools may sponsor separate teams for members of each sex where selection for such teams is based upon competitive skill.
Okay. So the only new ground this law paved was basically defining things based on sex at birth.
Yes.
Biological sex at birth, and then saying that transgender girls can't be on girls' teams.
Correct. Yes.
And it doesn't go the other way? Is that right?
As far as I know, this was only about transgender girls participating in girls' athletics. So
Interesting. So transgender boys could be on boys' teams.
According to this law, that law did not cover that piece of it.
Huh.
My understanding. So interestingly, this new law was not the first time that West Virginia had tried to address athletic participation by students whose gender identity differs from their sex assigned at birth. There was a 2016 policy by the West Virginia Secondary Schools Activities Commission that said transgender students could join teams matching their gender identity if, but only if, their school determined that, quote, fair competition, unquote, would not be impacted by the students' participation.
Interesting. Okay.
Yeah. So the policy allowed an appeal process that required the commission to look at issues related to that competitive equity kind of thing and student safety. And this involved considering things like the student's age, athletic experience, strength, size, speed, the nature of the sport, and the degree to which fair competition would be impacted. So they had this thing in place, right, that basically allowed transgender folks to participate on whatever teams they felt comfortable with. But if there was a disagreement or a dispute or a concern about that participation impacting the competitive fairness
or
right?
safety,
there's an appeal process that looks at all those issues.
Right.
Okay.
And I really like that approach. Like, because one of the things that about this topic that really strikes me is like, there's the legal questions and then there's the practical questions. And like the law is in many ways a blunt instrument, and it is not all that great often at like really contextualizing and making these really like fine-tuned distinctions. And like in this situation, I don't think a categorical prohibition or a categorical like anyone can play on any team they want. Like, I don't think either of those practically works. So I really like this policy because it requires individual determinations. It is inclusive as a default. And, you know, it takes into account all of the different contextual factors.
Yeah.
So like,
yeah.
I like West Virginia's old policy.
Yeah. Yeah. I mean, it doesn't raise a whole bunch of red flags to me. You know, it like you said, it's inclusive as a default as opposed to discriminatory as a default, right? Like that's its starting point.
Right.
And then there are other considerations, other aspects to it that allow you to negotiate the nuance and negotiate the complexity of these kinds of situations. Because like when it comes to athletic experience, strength, size, speed, age,
right. Or the
like,
athletic
there's a lot
activity,
of difference,
right?
Yeah.
Like football is very different than track and country.
Yeah.
Track and field. Oh my God.
Track and field.
Cross country, track and field.
Track and field.
Yeah. We're doing great.
It's so, but it doesn't matter because that was the old way.
And now they changed it. Yeah.
Right. The new law was a very substantial change to that. And it required that all public high school and college sports teams be expressly designated as males, men, or boys, or females, women, or girls, or co-ed or mixed. So one, the other, or both.
Right.
I guess.
And to your point, I think it's really interesting that they said males, men, or boys. Because like male tends to be more aligned with like what we understand as like biological sex, whereas boy tends to be much more aligned with like gender expression. So like already by including all of those words, you're kind of recognizing that like you're like doing more here than just regulating based on reproductive anatomy.
Right. You are acknowledging that there are layers to the terms.
Right. Yeah.
It required those designations to be based solely on biological sex. All right. So it was basically defining all of these terms as this is, whether you want to call it a male, a boy, man, that it's all based on biological sex.
Right.
And that was whatever biological sex they were assigned at birth. So what happened was Becky Pepper Jackson, a transgender female, entered the picture here. The court calls her BPJ. And at the time of the case, Becky was in the 8th grade. Okay. She wasn't in high school yet. And at birth, Becky's sex was assigned as male. But since the 3rd grade, she had publicly identified as a girl. And she had been taking, she had also been taking puberty blocking medication since then as well.
Right. So 5 years at this point, she's been presenting as a girl.
And so in 8th grade, she wanted to run on the school's cross country and track teams, which were on the separated male and female. Okay. And she wanted to run on the girls' cross country and track teams.
Right.
All right.
Makes sense.
Yeah. And so basically, those are the facts.
Right. Because this new law wouldn't let her do that.
Yeah. And so what happened?
Within a month of the new law taking effect, Becky filed a lawsuit in federal court arguing that the State Board of Education and the Athletics Commission violated the Equal Protection Clause and Title IX by forbidding her from participating on the girls' teams.
Okay, now we've talked about those two things before. They come up quite a bit when it comes to anything discrimination related, right?
Right. Yeah, these are the two big ones when we're talking about sex discrimination, right?
Yeah.
So the Equal Protection Clause comes from the 14th Amendment to the United States Constitution. It guarantees everyone, get this, the equal protection of the laws. Probably where I got its name.
You're using it in the definition again.
I'm maybe. Hey, this is a one-way podcast.
Yeah, that's right. That's right.
In recent decades, the Supreme Court has interpreted the Equal Protection Clause to forbid the government, so that's important, it's got to be the government doing the line drawing, from intentionally treating similarly situated individuals differently without a sufficient governmental justification. Essentially, if there are two people who are the same in all relevant aspects, you, the government, need to have a good reason for treating them differently.
But isn't part of the argument here that these things are not the same?
And that is the line drawing issue, right? Like, it's like, how do you
draw the line?
Who do you decide to compare it to, right? Like,
right.
That's actually one of the big fights in this case is like, who should we compare Becky to? Do we compare Becky to cisgender girls?
Yeah.
Whose gender identity aligns with their sex assigned at birth?
Right.
Or do we compare Becky to other individuals who were assigned the male sex at birth? Right. And so like those two things lead to very different kinds of analyses depending on who we decide to compare, who the comparator is, to use the fancy legal term.
Okay. I love legal terms.
Aren't they fun?
No.
And then Title IX, on the other hand, is a federal statute. We've talked about it a bunch. That prohibits discrimination by those who receive federal funds from discriminating on the basis of sex. What that means in practice, like, it was enacted in, I think, 1972.
Yeah.
And so, like, that phrase, on the basis of sex, like, it's been a constant fight about what that phrase means.
Yes.
Partially because of all the reasons we've already talked about with the challenges in definitions and line drawing and all of that stuff.
Right.
But one interesting thing about Title IX is, unlike the Equal Protection Clause, if you, the plaintiff, can show that you were treated differently and adversely affected based on your sex, that's the end of the story. It doesn't look to see if there's like sufficient governmental justification, because under the Equal Protection Clause, like, how you're drawing the line determines how strong of a justification you need. We call that tiers of scrutiny.
Yeah.
But under Title IX, it's like, oh, well, no, you were treated differently. You were harmed because of it. You pass go.
Well, and that's, so the big issue with respect to Title IX is, how do we define sex?
And that has been a huge fight.
That's been a huge fight.
The Biden regulations that we talked about in previous episodes that have been put on hold, and we've gone back to the old Trump regulations, they included gender identity discrimination in their understanding of what discrimination based on sex was.
But we also have Supreme Court cases that have touched on this as well, like the
Title VII case context, which is a law that Title IX was based off of.
Right, but I do believe that there was a dissent in that case that specifically referenced Title IX, because it was
Bostock?
case? Yeah, the Bostock case
Versus Clayton County. Yep.
Yeah, so that was the case about somebody who was fired because they
were transgender. Yeah,
they were transgender, and so that was a Title VII thing, employment.
Right, but the Supreme Court said in that opinion that
this could have implications for things like Title IX.
Right,
like
exactly.
There's something almost identical to that language,
right,
in there.
Yeah, because
they're recognizing that they are defining sex, right? Like that.
Right.
Honestly, like that's what they were recognizing, that by making that decision, regardless of what that decision is, they're kind of defining the term to include this or to include that. And that has implications in other places like Title IX. Like if you define
one of the big
sex
questions is
here,
if Bostock
is going to
should
get
influence
overturned.
these decisions, right?
Well,
not overturned, but like whether or not should it influence Title IX or the Equal Protection Clause, how we understand those laws.
Right.
Bostock looms large in a lot of these conversations.
Yeah. Yeah. Anyway, this is complicated.
It is complicated. But returning to our case, so Becky filed her lawsuit in 2021, quickly asked for a preliminary injunction, which the court granted. So Becky was asking for the court to basically hit the pause button to stop the new law from being applied to her and preventing her from being on the girls' teams. The court said, yeah, okay.
So it left the 2016 policy in place, which was she could be on whatever team she wanted,
right.
But there was this appeals process if they felt like her participation, or if people
was
felt like
unfair or unsafe. Yeah.
Okay. Got it.
Right. And so, in deciding for the preliminary injunction, the court said that Becky had a likelihood of success on the merits of her claims.
Mm-hmm.
And so while this was all going on, Becky was able to be on the girls' teams.
Okay.
And interestingly, the state didn't appeal that injunction decision, even though they could have. So the state was just like, okay, well, we lost that one. We'll just let the case keep going. So they didn't appeal that, which I find really interesting. So that meant that Becky was able to participate on the girls' cross country and track teams. And I was curious, so I wanted to see how she's been doing.
Okay.
Because
What'd
this
you
is a
find
big
out?
point, I'll tell you.
Okay.
This is a big point of contention in the dissent at the Fourth Circuit level. So the case we're talking about today also was a 2-1 decision. Is like whether or not having her participate in these activities is fair, right? And that's such a, like, that idea of fairness is looming so large in these conversations that, like, I think, that tends to be, I think, the primary counter argument to including individuals based on their gender identity on teams that align with that gender identity.
Yeah. It's not fair. Yeah.
Right. And, to me, there's more nuanced ways of addressing the fairness concerns that isn't just you can't be on the team. Like, there's so many alternatives that we could do that would still allow folks to participate without kind of like while addressing those fairness concerns. So like, in track and field, if Becky came in, so actually she made states in her freshman year in 2025. So she's a freshman now.
Okay.
And she came in 3rd in discus and 8th in shot put. So like, she's obviously doing well, impressive performance, but not necessarily dominating. Right. But like, I think there's so many more nuanced ways to address those fairness concerns potentially than just like saying you can't be on the team. Like if she came in 3rd, what if they just had 2 3rd place finishers, right? Just duplicate the place that she came in. And now it's still the same fairness. Everyone got to compete. The person who would have got 3rd if she hadn't competed still got 3rd.
Right.
Like, I just think there's so many other ways to do this, which is why I talk about the law as like a blunt instrument, right?
Right.
Interestingly, she wasn't the highest placing freshman in either of those events, though. There was another freshman that scored higher than her in both of those events. So, It's impressive that a freshman medaled in track and field, but she wasn't the only freshman.
Well, listen, and I think a lot, like you said, a lot of the argument centers on fairness, and I think digging a little more deeply into that argument, a lot of that argument is about, the fact that biologically speaking, that there may be differences in ability levels based on biology.
Right.
I think it's also very fair to say that within the same biological sex definition, there is also a vast amount of variation in ability.
Right.
Right?
Yeah, because drawing a line based on male female, like that is wildly inaccurate because not all men are stronger than all women, vice versa, right? Like it's one of those things, which is why, like, in this context, right, like Becky has been on hormone suppressors for longer than that at this point, like 8-9 years.
Mm-hmm.
She's never gone through puberty. She's never gone through male puberty. I don't know if that's the way you talk about it or not. So there's a question, like, does she have an advantage? Right.
Yeah. And I don't know how these puberty blockers work, and I don't know if it just slows the process down, or if it or if it prevents it completely, or I have no idea. But
I'm a doctor, but I'm not that kind of doctor.
No. We can write you a paper. That's about it.
So, and I couldn't find much about her cross country career, but based on what I could find, track and field seems to be much more her sport.
Okay, gotcha.
When it ultimately comes time to decide the case on cross motions for summary judgment, the lower court actually reversed course from its preliminary injunction and rejected both of Becky's claims.
Oh, really?
So Becky loses the cross motions for summary judgment, and the lower court instead held that under the Equal Protection Clause, West Virginia's definition of girl as being based on biological sex assigned at birth was substantially related to the important governmental interest of providing equal athletic opportunities, so kind of what we just talked about. And then for Title IX, the lower court said that existing Title IX regulations that allow for sex-separate sports teams, as long as athletic opportunities are equal, like that pretty much covered this situation. So based on the definition of sex that they're going with, that meant that Becky's claims couldn't succeed. And the court said that basically because Becky could still try out for the boys' team, she had equal opportunity, and that was all that Title IX required. So it didn't violate Title IX.
Got it.
Becky, not too thrilled with that outcome, because she's been playing on these teams for however many years now. She appealed to the Fourth Circuit Court of Appeals, and in a 2-1 decision, the Fourth Circuit reversed the lower court decision and sided with Becky.
Oh.
So on appeal to the Supreme Court, Becky has currently won the case, at least one of the claims. One of the claims they decided there wasn't enough evidence, so they kicked it back down, or they would have until the Supreme Court took the appeal.
Seems like the Fourth Circuit is developing a pattern on how they are handling these kinds of issues. Because the Gavin Grimm case is also out of the Fourth Circuit,
which was one of the big first ones to apply intermediate scrutiny to discrimination based on transgender status. Yeah. And that was a huge case.
Huge case.
And that is looming large here as well, because they have to apply that precedent.
Yeah.
So, for the equal protection, the big fight is that line drawing issue about, like, how do we draw the lines here? And then is there a sufficient justification once we know how they draw the lines? And so for their part, West Virginia is arguing that the lines drawn here are just based on biological sex assigned at birth, which is based on biological anatomy. And therefore, Becky should be compared to others who were assigned male at birth. And Becky is saying, that's not the right way to do it. You should compare me to other girls who align with my gender identity. And that's kind of the difference between the two opinions, is the majority says, no, we see Becky and we're going to compare her to other girls. And the dissent says, no, these are just drawing lines based on biological sex, and comparing her to other boys, she gets the same opportunities. That's all the law requires. So you can see how, like, drawing these lines really matters, because the consequence of those lines is what level of scrutiny gets applied. And so, the tiers of scrutiny basically just say, like, the worse the kind of line you're drawing, or the more questionable or problematic the line you're drawing is, the greater justification you need.
Yeah.
And so for discrimination based on race, we apply strict scrutiny, because discrimination based on race, racial classifications are really harmful. There's not a lot of good reasons to have them other than prejudice. And so those kind of laws or policies have to be necessary to accomplish a compelling governmental interest. So that's like the strictest scrutiny.
Yeah.
And then underneath that, you've got discrimination based on sex because, men and women are different. There are differences between men and women that would, in some situations, require different treatment. And so that's intermediate scrutiny. So
that's basically, it's basically why you can say, listen, as long as you have a boys' baseball team and a girls' baseball team, that's okay. You can't have a baseball team. You can't say, we're going to do a Jewish kids' baseball team and a Catholic kids' baseball team because, race and religion gets that higher. Is that like one way we can kind of think about the difference between intermediate and strict scrutiny?
Right. Yeah.
Right?
Yeah. So intermediate scrutiny, you have to have like, it has to be substantially related to an important governmental interest. So in your baseball example, like there's really no reason relative to baseball why your religion is going to affect how good you are at baseball. Right. Right. But for men and women, maybe there is. And so because of that, that's why we have this intermediate stage of scrutiny. And so you have to have a good reason. It has to be an important reason. Yeah. And it has to be substantially related. Your rule has to be substantially related to accomplishing that important reason, but it doesn't have to be necessary. And also it can't be based on impermissible sex stereotypes. Like basically you can't do it out of paternalistic justifications or just assumptions about how men and women should behave. Yeah. So there is some teeth to intermediate scrutiny, which is different than rational basis, which is often very deferential to the government because all it requires is that you have a legitimate governmental interest, which is literally just anything the government is allowed to do. And what you're doing has to be reasonably related to that. So it just has to be reasonable. And the reason this all matters is because right now there is an open question of law about whether or not gender identity discrimination or transgender discrimination gets intermediate scrutiny or rational basis review. And the Supreme Court has never spoken on that. The Fourth Circuit, though, Jamie, to your point earlier, has spoken on that. In the Gavin Grimm case, the Fourth Circuit said that discrimination based on gender identity and transgender status gets intermediate scrutiny. And the Supreme Court had a chance to answer that question last term.
But they didn't take up the case. Yeah.
Well, they did. They just decided the issue.
Yeah,
right.
The issue.
Yeah. 3 justices in dissents and concurring opinions, though, would have said transgender discrimination gets rational basis review. Yep. And so that fight, it really, really matters because rational basis review, the government's almost guaranteed to win. Intermediate scrutiny, it's a lot harder.
Right. And so do you think that this is where the Supreme Court is potentially going to zero in, in terms of what they're going to hone in on with this case is more of a line drawing thing or a scrutiny level of scrutiny kind of that's probably where they're going to.
Right. I think it's hard to predict what they're going to do. Yeah. Because they didn't address the question of what level of scrutiny to apply to gender-based discrimination or gender identity-based discrimination last term. I don't see them going there this term.
But they did take up this case.
I see them doing a line drawing thing about this is not discrimination based on gender identity. This is discrimination based on sex. Therefore,
so they're going to
apply intermediate scrutiny, but it's going to be based on sex-based discrimination, not gender identity-based discrimination.
So they're going to potentially draw a much firmer line between, and define what is sex, what is gender identity
in a very narrow way.
Narrow way. Yeah.
That's that's my guess, but I've been wrong before.
It's a court that can be tough to predict.
It is, yeah. And especially because like you said, this is so complicated and there's so many off ramps, I guess is a good way to say it in this case where they could avoid addressing a lot of these issues if they wanted to. Right. They could basically say oh, well, the commission isn't a state actor, so therefore you can't sue them under the Equal Protection Clause because that only applies to the government. Yeah. They could there's so many ways to sidestep
technicalities. I mean,
I take offense at calling them technicalities as an attorney because that's all I ever do. But
no,
yes.
but like that's their sides. There are big issues at play here, and that's why these cases are cases. And so, rather than actually dealing with the issues at hand, they're going to find something about it, which is an important thing because those distinctions about who is the government and who isn't those are important distinctions to make.
Right. Because that was the whole issue in the charter school, religious charter school case out of Oklahoma.
Yeah, exactly. But yeah, I see that. I get the importance. I get why, but I also see the fact that, these cases are here for a reason and you're not going to deal with the reason. I mean, we're not saying that's what's going to happen this time, but like that happens a good bit in the courts.
It does. Yeah. But that is also like a benefit too, because it allows these issues to kind of percolate to your earlier point, like, and for them to be more fully developed and for us to like really get fine tuned about where these things, because like the worst thing that can happen is the Supreme Court comes in with a wrecking ball.
Yes.
And like makes a massive ruling and then like realizes in 6 months, they're like, oh my goodness, that's not going to work.
No. Yeah, exactly.
Which is, kind of how we got West Virginia v. Barnett, because that was overturning a case that was decided like a year before that.
Right. Yep.
So back to this case, like the big, we already kind of talked about like, is this gender identity discrimination? Is it transgender discrimination? Or is it just discrimination based on sex? The state really just admits like, yeah, this is discrimination based on sex. Like we're not arguing that because we have sex differentiated sports teams, right?
Mm-hmm. Right.
So like, yeah, it's discrimination based on sex, but it's not discrimination based on transgender status. The court says, no, that's kind of a too limited way to read that.
Yeah.
For the court, like the purpose and effect is to treat girl transgender students differently than cisgender students and even male transgender students, because male transgender students
they're not even part of the
boys sports teams.
Yeah.
And so the court calls this a facial classification based on gender identity. And according to Fourth Circuit precedent, that triggers intermediate scrutiny because that's essentially like that is discrimination based on sex, because you can't figure out if someone's gender identity doesn't align with their biological sex without reference to sex, right? So like it's kind of baked into the definition of transgender discrimination. And so for the court, they're going to apply intermediate scrutiny. And because of intermediate scrutiny, like it has to be substantially related to a legitimate or an important governmental interest. The law doesn't meet that because we don't really have safety concerns here. We have fairness concerns. And the record, according to the court, is undeveloped or there's a question of fact, rather, about whether or not Becky has any sort of competitive advantage in this because, she's been on these medications since third grade. She's never gone through puberty. The court digs into the science of it, which I probably understand as well as these judges. But that's why we have expert witnesses.
Yeah.
And so they talk about, I think it's like testosterone and Tanner 2 stages and all this other stuff.
So
and like
they're
Becky hasn't gone through that.
They're just looking at, does she have a biological advantage,
right?
And they're basically
if she doesn't, then there's no rational relationship between what you're doing and how you're doing it. Because if she doesn't have an advantage because of her sex assigned at birth,
why are you making that?
Why are you preventing her, right? And so that would mean that there isn't a good enough fit between what the government's doing and their justification for it.
Okay.
And so, the Equal Protection Clause, the majority kicks that back down to kind of further develop the factual record and make those determinations of fact about whether or not there's any kind of competitive advantage. The dissent obviously sees things differently. For the dissent, the law is only treating biological boys differently than biological girls. So instead of comparing Becky's opportunities to those who share her gender identity, the dissent would compare them to compare her to only those who share her biological sex. And since all biological boys are treated the same and all biological girls are treated the same, the court kind of says, no, this doesn't violate the Equal Protection Clause. Or the dissent says that it doesn't violate the Equal Protection Clause. The dissent also rejects the idea that the law facially discriminates based on transgender status. And that's, I think, really interesting because that's kind of what the court in Adams, which was a transgender student bathroom case that said that you could keep sex-separated bathrooms and exclude transgender individuals from bathrooms that align with their gender identity. That's kind of how they did it too. They kind of said like, this isn't facial discrimination, it's sex discrimination. And, you know, that's okay because we've always kind of separated men and women in these kind of private spaces. And so for the dissent, the law doesn't explicitly discriminate against transgender individuals, and nowhere does it say anything about transgender individuals. It doesn't say anything about gender identity. It just defines sex based on biological sex assigned at birth, which, you know, the dissent admits like may effectively treat transgender students differently, but that doesn't necessarily make it facially discriminatory, because you would have to prove a discriminatory intent behind the law in order to kind of trigger that kind of elevated scrutiny if it's not facially discriminatory. And to me, like, this argument seems to be a little too, it seems to be like purely semantic. And I know I say that having just taken offense at that kind of lawyerly line drawing.
Yeah.
But like, the law doesn't use the word transgender or gender identity. Sure, it doesn't say that, but it effectively defines them out of our understanding of sex. So Jamie, you talked about like layered understandings of sex, right? Like, and I think that like defining the term in a way that removes some of the layers, that is facially discriminatory based on the layers you removed. So like I was trying to think of a metaphor for this, and the best I could come up with is it's like saying that all peanut butter and jelly sandwiches can only have brown ingredients. The rule doesn't say no jelly, so we're not discriminating based on against jellies, but it essentially keeps jelly off the sandwich, right? And so no one's going to look at my peanut butter and jelly sandwich rule and say like, oh, well, that's totally fair to jelly, right? Well, and I probably wouldn't want to eat a peanut butter and jelly sandwich that had brown jelly.
I don't know what to say about this. I like the
it's
analogy.
It's a thinker, isn't it?
Yeah, no, I like the analogy. No, it's a good way to describe that. Yeah.
So all that to say, 2 votes is more than 1 vote. So the court applies intermediate scrutiny because of that lack of fit between the competitive fairness concern and Becky's circumstances. The court says, we're going to kick this down to the lower court to develop the factual record and make these factual determinations. So what about Title IX? So they're slightly different, Title IX and the Equal Protection Clause, but they're similar in a lot of ways. The big difference under Title IX is to prove a Title IX claim, you have to show that you were treated worse than someone else who was similarly situated, and that you suffered harm because of that worse treatment, and that because that treatment was because of your sex. And, you know, for all of the same reasons we just talked about, the majority says Becky was treated worse because of her sex, because of her, which, you know, includes her gender identity, and she was treated differently because she's a transgender girl. Obviously, she was harmed by this. She's been presenting as a girl since 3rd grade. Everyone knows her as a girl, requiring her to try out for the boys' team. Like, not only is that, you know, incredibly harmful for her self-image and all of those things, but like, that's really no choice at all for her because she's a girl. And so, you know, the court says because of all of that, like, this also violates Title IX. And under Title IX, we don't even look to see if the state has a good justification because they drew the lines in a problematic way. That's it. Again, the dissent sees things differently. You know, for them, we're comparing Becky to biological boys assigned male at birth. And because of that, she has the same opportunities that they do. So no Title IX violation. The dissent makes a couple interesting arguments that I also think might get play at the Supreme Court. One is the dissent says that if we expanded Title IX to include gender identity discrimination, that would violate the spending clause. So Title IX is a spending clause statute because it gives money to states and local educators or educational institutions. And in accepting that money, they have to agree to the terms, right? And one of the terms of Title IX is don't discriminate based on sex. And courts have been recently kind of saying like, well, you got to know what you're agreeing to up front. Otherwise, like, it's kind of a gotcha. It's not fair. It's a gotcha game, essentially. Like, hey, you took this money, and guess what? There's more strings attached than you realize. And so the dissent would have said that, you know, that's another reason to not expand Title IX to gender identity based discrimination. You know, one thing I think is tricky in that regard, though, is the Supreme Court has recognized that discrimination based on sex stereotyping is discrimination based on sex. So basically, if you discriminate against someone for not being masculine enough, so if you discriminate against a man for not being masculine enough, that's sex discrimination, right? And same thing for a woman who's not feminine enough. And it's one step from there to say like, okay, well, someone who doesn't act in the way you expect a man to act based on their gender identity, like that is sex stereotyping discrimination. And they've said that that's, that under Title IX, Title VII, like that sex stereotyping is valid, right? It's discrimination. And so like, that to me, like makes that a little bit of a trickier argument to make. And also the dissent spends a significant amount of time saying that Grimm should have been, that Grimm was wrongly decided. Like of the, I think 13 or 15 page dissent, 10 pages are dedicated to arguing that like Grimm was wrongly decided.
Interesting.
And for all the reasons we kind of talked about, like basically saying that transgender status shouldn't be a protected class. And so to be a protected class, there's certain things you have to meet. You have to have a history of discrimination. You have to kind of show that you've got common characteristics across the class. And you have to show that, the class as a group lacks kind of the ability to protect their interests through the political process, so that they're a minority without, kind of enough political juice to adequately protect their interest. And so like the dissent here is saying like, okay, well, transgender-based discrimination isn't really discrimination based on sex. And there's no reason to elevate scrutiny just for transgender discrimination on its own terms because of these things. So if the Supreme Court does get to that question, they'll have to navigate whether or not transgender status is discrimination, or transgender discrimination is discrimination based on sex, or if it's not, whether or not it is deserving of elevated scrutiny by itself.
Oh man.
Yeah. So it's going to be a tricky one. So, Becky won the Title IX claim at the trial court, and there was an open question about the equal protection claim. It's going to be anybody's guess what this, I say that, but I kind of know what the Supreme Court's going to do. It's just a question of like, how are they going to do it?
Yeah, exactly.
Right? And I would love to be surprised, because I was surprised by Bostock, I think, yeah. Bostock versus Clayton County, because
I think
that
we
was
all
only
were,
decided a couple years ago. And it was Gorsuch.
I think so, yeah.
Wrote the opinion, joined by, at that time, 4 liberals on the court to side with the transgender employee. And so like, it's one of those things where it's like, maybe they will surprise us, but it's going to be a question of kind of like, how do they navigate this? Because it is a really thorny case from a legal perspective for a lot of reasons.
Right. And I think
with huge implications.
With massive implications. And I think that massive in terms of the precedent that it's going to set. I don't think it's going to so drastically, at least based on what I read, a while ago, I don't think it's going to so drastically change one way or the other the current playing field, for lack of a better phrase, because the actual numbers here
there's a difference between like the practical impact and the legal impact. Like there's a way to decide this case where the legal impact is massive, because they could basically say transgender discrimination does not get heightened scrutiny. And that would be huge, because that would basically like green light a lot of differential treatment for
transgender folks,
these individuals. And so like there's a massive question there that could have huge implications. But like, you're right, like the issue of transgender student athletes, there aren't that many,
right?
Or they're a very small segment of the population, but like for these individuals, like it's so
this is
core to their like identity, right? 100%. So like it's massively important for them.
Yeah, I wasn't saying it to kind of downplay that. No. It was just sort of the broader impact might not be practically all that massive, but for those individuals that this does affect, it is like it is going to be massive, one way or the other.
Right. Yeah. I remember when the issue of transgender students and which bathroom they should use was coming through the courts. It's been percolating for about a decade now, and it was actually when I think the trial court had decided Grimm for the first time. And I was teaching a class with a practicing school principal. And, you know, his takeaway was like, he told the students, this is an illegal question. This is a facilities issue. And like, that really stuck with me, because it's like, yeah, the law is going to come in and say yes or no, or which way this should go. But like, really, it's a practical concern that we can address in other ways without involving the like blunt instrument of the law.
Right.
And, you know, I think that like, if we could do that here, there's a lot of potential room for common ground without kind of resorting to that blunt instrument, right?
You know what? And I think that is probably the best place to leave this. And the biggest takeaway here is that you're right. The law is a blunt instrument. And more often than not, I would say there are plenty of commonsensical, practical ways that allow, you know, in this case, for example, or similar kinds of cases, for us to focus on the dignity of the individual, of all individuals, all individuals, without having to retreat to that blunt force of the law. We can maintain our legal compliance by getting a little creative, okay? And as a result, we could potentially maintain everybody's dignity, their sense of self-worth, their identity, all of that
their
stuff.
Athletic opportunities, fairness,
everything.
Safety.
Like we've just got to be, you know, I think we've got to try to put more of our energy into looking for those solutions rather than trying to retreat to our corners. You know, it's important to fight for what we believe in. Absolutely. 100%. But like, we also have to recognize the cost of that fight. And if that, you know, if there are other ways to achieve goals of everybody being treated fairly, appropriately, all of that stuff, let's look for those solutions too.
Yeah.
You know, let's fight those fights as well. Anyway.
I'm here for it.
Yeah. Okay. Well, Colonel, we are just about out of time for today, and you've got a mystery that you need to solve.
Right. You know,
so give us our
probably
homework.
me with the textbook in the office.
All right. What's our homework, sir?
Your homework is to go check out Chalk and Gavel's new website. Like, it is seriously beautiful. Sign up for our mailing list.
Yes, please do that.
That's going to be fun. We're going to be in a little closer contact with you all. You can find us on social media at Chalk and Gavel. We're on, what are we on? We're on X, Instagram, Facebook. YouTube is a big one. Yeah. Please go check us out on YouTube, even if it is just to see my admittedly ridiculous facial hair at the moment.
I'll try to turn one of these things into a reel, and
it's growing on me a little bit, though.
Oh boy.
Yeah.
Don't
get ready.
Yeah. No, I don't think. What does your wife have to say about this?
Oh, she is not a fan.
No.
No. I already have plans of what I'm going to do on November 1st.
I'm sure. I was actually thinking about the other day. I was like, what's he going to do? Is he going to is he going clean shaven? Is he going to keep the stash? Like,
I'm going to try a stash. We're going to see what happens.
Really?
Yeah.
Oh,
yeah. I'm interested to see, because I think it's going to be like.
Well, they're coming back.
They are coming back.
They're coming back. I don't think I can pull it off.
And if I've got the confidence to rock this for 2 weeks, I think I can. I'm not worried about it.
Yeah, man, you know, more power to you. Okay, folks. Well, that does it for another episode of Chalk and Gavel. We will follow this one all the way through. We'll keep you posted. So have a good one and be kind to one another. Bye.